Hello, my name is Thomas Scott, and this is the Week 1 reading for Business 280 Business Law. I'm recording this for audio learners like myself who find it hard to sit and read the book and prefer to listen instead. Also, it's possible to speed up the audio, skip to certain sections, and review. I don't read any of the summaries or any of the extra things on the side. I just kind of stick to the meat, and you're welcome to go back and review all the extra potatoes and all that stuff on your own time. But this will help you just like either play before bed or as you're working on something else with your hands, like I like to do, multitask. This is a good way to get it kind of just imprinted in your brain one way or another. Thank you.
Three, two, one. Chapter 2 begins on page 14 with the court system. Despite carefully negotiated and well-written contracts and high safety standards in the workplace or in product design and production, businesses can end up in a lawsuit. For example, you could hire the brightest and most expensive lawyer in town to prepare a contract with another party and believe the final agreement is bulletproof. However, even a bulletproof contract does not guarantee performance by the other party, and you may have to file a suit to collect your damages. Business disputes can be resolved in court or through alternative dispute resolution. This chapter covers the structure of the court system and the litigation process, as well as the forms of alternative dispute resolution. A court is a tribunal established by government to hear evidence, decide cases. A court is a tribunal established by government to hear evidence, decide cases brought before it, and provide remedies when a wrong has been committed. As discussed in chapter 1, sometimes courts prevent wrongs by issuing the equitable remedy of an injunction. For example, in May of 2012, a federal court issued an injunction against Cardinal Health because it was shipping too much oxycodone to its pharmacies in Florida, and the FDA had discovered that the prescriptions were fraudulent. The FDA needed to stop the flow of the drug while it pulled the prescriptions. The types of courts. Each type of court has the authority to decide certain types of classes of cases. The authority of courts to hear cases is called jurisdiction. One form of jurisdiction, subject matter jurisdiction, covers the type of cases the court has the authority to hear. Courts that have the authority to hear the original proceedings in a case, the trial court, are called courts of original jurisdiction. For example, in a court of original jurisdiction, witnesses testify, documents are admitted into evidence, and the jury, in the case of a jury trial, hears all the evidence and then makes a decision. Other types of subject matter jurisdiction give courts the authority over particular legal topic areas. A court with general jurisdiction has broad authority to hear general civil and criminal cases. When a general jurisdiction trial court hears criminal cases, it serves as the trial court for those charged with crimes. General trial courts also have the authority to hear civil disputes such as breach of contract cases and personal injury lawsuits. A court with limited or special jurisdiction has the authority to hear only particular kinds of cases. For example, many states have courts that can hear only disputes in which the damages are $10,000 or less. Other examples of limited or special jurisdiction courts are juvenile courts, probate courts, and domestic relations courts. States vary in the names they give these courts, but these courts of special or limited jurisdiction have very narrow authority for the types of case they hear. In the federal court system, limited or special jurisdiction courts include bankruptcy courts and the U.S. tax court. A court with appellate jurisdiction reviews the work of a lower court. For example, a trial court may issue a judgment that a defendant is in a breach of contract suit should pay $500,000 in damages. That defendant could appeal the decision to an appellate court and seek review of the decision itself or even the amount of the damages. An appeal is a page 15. An appeal is a review of the trial and decision of the lower court. An appellate court does not hear, witness, or take testimony. An appellate court, usually a panel of 3 judges, simply reviews a transcript and evidence from the lower court and determines whether there has been reversible error. A reversible error is a mistake in applying the law or a mistake in admitting evidence that affected the outcome of the case. An appellate court can affirm or reverse a lower court decision or remand that decision for another trial or additional hearings. There's a case summary that follows. You're welcome to go through that. I will not. Then we are on page 16. 1 second. Page 16. Page 16 starts with the federal court system. The federal court system consists of 3 levels of courts. Figure 2.1 illustrates federal court structure. There's a figure down here located at the bottom of the page. It basically says it's a hierarchy of the court systems, starting at the top with the U.S. Supreme Court, dropping down the U.S. Courts of Appeals, federal district courts, and then spread out to specialty courts like bankruptcy court, tax court, U.S. Claims Court, Court of Military Appeals, and the U.S. Court of International Trade. You're welcome to look at the figure 2.1 reference when you have on your own. Federal district courts. Continuing on. Federal district courts. The federal district courts are the general trial courts of the federal system. They are courts of original jurisdiction that hear both civil and criminal matters. Criminal cases in federal district courts are those in which the defendant is charged with a violation of federal law, the U.S. Code. In addition to the criminal cases, the types of civil cases that can be brought in federal district courts include civil suits in which include 1. Civil suits in which the United States is a party. 2. Cases between citizens of different states that involve damages of $75,000 or more. And 3. Cases that arise under the U.S. Constitution or federal laws and treaties. Federal district courts are organized within each of the states. There are 94 federal districts. Each state has at least one federal district, and there are 89 federal districts in the United States, with the remaining courts found in Puerto Rico, Guam, and etc. Puerto Rico, Guam, etc. Judges and courtrooms are assigned according to the caseload in the geographical area of the state. Some states, such as New York and California, have several federal districts. Some states like New York and California have several federal district states. Page 17 consists of a figure 2.2 is a map. It looks like it's outlining the courts. So New York and California, several district states of the population base and the resulting caseload. Figure 2.2 above shows the geographical structure of the federal court system, including the appellate circuits. That's on page 17 once again. The federal system has additional trial courts with limited jurisdiction, differing from the general jurisdiction of the federal district courts. These courts include, for example, the federal bankruptcy courts, Indian tribal courts, tax court, court of federal claims, court of federal claims, court of veterans appeal, and the court of international trade. U.S. Courts of Appeals. The final decision in a federal district court can be appealed to a court with appellate jurisdiction. In the federal court system, the federal districts are grouped together geographically into 12 judicial circuits, including one from the District of Columbia. Additionally, a 13th federal circuit called the Federal Circuit hears certain types of appeals from all of the circuits, including specialty cases such as patent appeals. Each circuit has an appellate court called the U.S. Court of Appeals, and the judges for these courts review the decisions of the federal district courts. Generally, a panel of 3 judges reviews the cases. However, some decisions, called en banc decisions, are made by the circuit's full panel of judges. For example, in 2003, the Ninth Circuit heard an appeal on a father's right to challenge the requirement that his daughter recite the Pledge of Allegiance in the public school she attended. The contentious case had so many issues that the Ninth Circuit issued 3 opinions, and the 3rd opinion was issued after the case was heard. En banc. Page 18. U.S. Supreme Court. The final court in the federal system is the U.S. Supreme Court. The U.S. Supreme Court has an appellate jurisdiction over cases that are appealed from the federal courts of appeals, as well as from state supreme courts when a constitutional issue is involved in the case or state court has reversed a federal court ruling. The U.S. Supreme Court does not hear all cases from the federal courts of appeals, but has a process called granting a writ of certiorari, which is a preliminary review of those cases appealed to decide whether a case will be heard or allowed to stand as ruled on by the lower courts. The Supreme Court in the only court The U.S. Supreme Court is the only court expressly created in the U.S. Constitution. All other courts in federal system were created by Congress pursuant to its constitutional power. The Constitution also makes the U.S. Supreme Court a court of original jurisdiction. The U.S. Supreme Court serves as a trial court for cases involving ambassadors, public ministers, or consuls, and for cases in which 2 states are involved in a lawsuit. For example, the U.S. Supreme Court has served for a number of years as the trial court for Colorado River water rights case in which California, Nevada, and Arizona are parties. State court systems. General trial courts. Most states have trial courts of general jurisdiction that may be called superior courts, circuit courts, district courts, or county courts. These courts of general and original jurisdiction usually hear both criminal and civil cases. Cases that do not meet the jurisdictional requirements for the federal district courts would be tried in these courts. Figure 2.3 illustrates a sample state court system. Looks like figure 2.3 is located on page 19, I believe. Moving on. Specialty courts. Most states also have courts with limited jurisdiction, sometimes referred to as a specialty court. For example, most states have juvenile courts or courts with limited jurisdiction over criminal matters that involve defendants who are under the age of 18. Other specialty courts or lesser courts in the state are probate and family law courts, city, municipal, and justice courts. Cities and counties may also have lesser courts with limited jurisdiction, which may be referred to as a municipal court or justice courts. These courts generally handle civil matters in which the claim made in suit is an amount below a certain level, such as $5,000 or Oh, there's figure 2.3 on page 19. 5,000 ore, 5,000 ore. Wait, what happened here? Shoot. Man, this is slow. Okay, come on. Computer's taking its time. Sorry. Oh, at the bottom of figure 2.3 on page 19. We're on page 19. 5,000 or 10,000. These courts may also handle misdemeanor types of offenses such as traffic violations or violations of noise ordinances and the trials for them. Small claims courts. Most states also have small claims courts at the county or city level. These are courts of limited jurisdiction where parties with small amounts in dispute may come to have a third party, such as justice of the peace or city judge, review their disputes and determine how they should be resolved. A true small claims court is one in which the parties are not permitted to be represented by counsel. Rather, the parties present their cases to the judge in an informal manner without the strict procedural rules that apply in courts of general jurisdiction. Small claims courts provide a faster and inexpensive means for resolving a dispute that does not involve a large amount of claim damages. State appellate courts. Most states also have intermediate level courts similar to the federal courts of appeals. They are courts with appellate jurisdiction that review the decisions of lower courts in the state. Decisions of the general trial courts in a state would be appealed to these courts. We're on page 20. Page 20. State Supreme Courts. The highest court in most states is generally known as the State Supreme Court. But a few states, such as New York, may call their highest court to the Court of Appeals. Maine and Massachusetts, for example, call their highest court the Supreme Judicial Court. State Supreme Courts primarily have appellate jurisdiction, but some states' courts do have original jurisdiction, such as Arizona, where the most state Supreme Courts also have a screening. Oh shoot! Okay, sorry about that. State Supreme Courts primarily have appellate jurisdiction, but some states' courts do have original jurisdiction, such as Arizona, where counties in litigation have their trial at the Supreme Court level. Most state Supreme Courts also have a screening process for cases. They are required to hear some cases, such as criminal cases in which the defendant has received the death penalty. A decision of state Supreme Court is final except in those circumstances in which a federal law or treaty in the U.S. Constitution is involved. Cases with these federal subject matter issues can then be appealed to U.S. Supreme Court. Court procedure. Once a party decides to use the court system for a resolution of a dispute, that party enters a world with specific rules, procedures, and terms that must be used to have a case proceed. Participants in a court system. The plaintiff is the party that initiates the proceedings in a court of original jurisdiction. In a criminal case in which charges are brought, the party initiating the proceedings would be called the prosecutor. The party against whom the civil or criminal proceedings are brought is the defendant. A judge is the primary officer of the court and is either an elected or an appointed official who presides over the matters brought before the court. Attorneys or lawyers are representatives for the plaintiff and the defendant for purposes of presenting their cases. Lawyers cannot disclose what their clients tell them unless the client is committing or plans to commit a crime. A jury is a body of citizens sworn by a court to reach a verdict on the basis of the case presented to them. Jurors are chosen for service based on lists compiled from voter registration and driver's license records. Which law applies? Conflicts of law. When a lawsuit is brought, there is not just the question of where a case will be tried, but also of what law will be applied in determining the rights of the parties. The principle that determines when a court applies the law of its own state, the law of the forum, or some foreign law is called conflict of laws. Because there are 50 state court systems and a federal court system, as well as a high degree of interstate activity, conflicts of law questions arise frequently. Some general rules apply. For example, the law of the state in which the court is located governs the case on a procedural issue and rules of evidence. In contract litigation, the court appeals the law of the state in which the contract was made for determining issues of formation. Performance disputes and damages for non-performance are generally governed by the law of the state where the contract is to be performed. International contracts follow similar rules. For example, a California court will apply Swiss law to a contract made in Switzerland that is to be performed in that country. However, it is becoming more common for the parties to specify their choice of law in their contract. In the absence of a law selecting provision in the contract, there is a growing acceptance of the rule that a contract should be governed by the law of the state that has the most significant contacts with the transaction. For example, assume the buyer's place of business and the seller's plant are located in Nebraska, and the buyer is purchasing goods from the seller to resell to Nebraska customers. Many courts will hold that this is a contract governed by the law of Nebraska. In determining which state has the most significant contacts, the court considers the place of contracting, negotiating, and performing, the location of the subject matter of the contract, and the domicile, residence, states of incorporation, and principal place of business of the parties. Initial steps in a lawsuit. The following steps in a lawsuit generally apply in cases brought in courts of original jurisdiction. Not every step applies in every case, but understanding litigation steps and terms is important for business people. Is that one word? Commencement of lawsuit. A lawsuit begins with the filing of a complaint. The complaint generally contains a description of the wrongful conduct and a request for damages, such as a monetary amount. For example, a plaintiff in a contract suit would describe the contract, when it was entered into, and when the defendant stopped performance on the contract. A copy of the contract would be attached to the complaint. Service of process. Once the plaintiff has filed the complaint with the proper court, the plaintiff has the responsibility of notifying the defendant that the lawsuit has been filed. The defendant must be served with process. Process, often called a writ, notice, or summons, is delivered to the defendant and includes a copy of the complaint and notification that the defendant must appear and respond to the allegations in the complaint. The defendant's response and the pleadings the defendant's response and the pleadings. After the defendant is served with the process in the case, the defendant is required to respond to or answer the complaint within the time provided under the court's rules. In answering the plaintiff's complaint, the defendant has several options. For example, the defendant could make a motion to dismiss, which is a request to the court to dismiss a lawsuit on the grounds that, even if everything the plaintiff said in the complaint were true, there is still no right of recovery. A motion to dismiss is also called a demurrer. A defendant could also respond and deny the allegations. A defendant could also respond and deny the allegations. For example, in a contract lawsuit, the defendant seller could say he did not breach the contract but stopped shipment of goods because the plaintiff buyer did not pay for the goods in advance as the contract required. A defendant could also counterclaim in the answer, which is asking the court for damages as a result of the underlying dispute. The defendant seller in the contract lawsuit might ask for damages in the counterclaim for the plaintiff's buyer's failure to pay as their contract required. All documents filed in this initial phase of the case are referred to as the pleadings. The pleadings are a statement of the case and the basis for recovery if all the facts alleged can be provided. Discovery. The Federal Rules of Civil Procedure and similar rules in all states permit one party to obtain from the adverse party information about all witnesses, documents, and other items relevant to the case. Discovery requires each side to name its potential witnesses. Requires each side to name their potential witnesses and to provide each side the chance to question those witnesses in advance of the trial. Page 22. This is page 22. Each party also has the opportunity to examine, inspect, and photograph books, records, buildings, and machines. Each examining the physical or mental condition of a party is part of discovery. Even examining the physical or mental condition of a party is part of discovery when it has relevance to the case. The scope of discovery is extremely broad because the rules permit and question. The scope of discovery is extremely broad because the rules permit any questions that are likely to lead to admissible evidence. Deposition. A deposition is the testimony of a witness taken under oath outside the courtroom. It is transcribed by a court reporter. Each party is permitted to question the witness. If a party or witness gives testimony and if a party or a witness gives testimony at the trial, this is inconsistent with her deposition testimony. The prior inconsistent. Oh my God! I'm sorry, I mutilated that sentence. One more time. If a party or a witness gives testimony at the trial, this is inconsistent. If a party or a witness gives testimony at the trial, that is inconsistent with her deposition testimony. The prior inconsistent testimony can be used to impeach the witness's credibility on trial. Depositions can be taken either for discovery purposes or to preserve the testimonial of a witness who will not be available during the trial. Some states now permit depositions to be videotaped. A videotape is a more effective way of presenting deposition testimony than reading that testimony at trial from a reporter's transcript, because jurors can see the witness and the witness's demeanor and hear the words as they were spoken, complete with inflection. Other forms of discovery. Other forms of discovery include medical exams, particularly in case says in which the plaintiff is claiming damages for physical injuries, written written questions and written request for production of documents are discovery requests that can be very time consuming to the answering party and often lead to pretrial legal disputes between the parties and their attorneys as a result of the legal expenses involved. Motion for summary judgment. If a case has no material facts in dispute, either party can file a motion for summary judgment using affidavits or deposition testimony obtained in discovery. The court can find that there are no factual issues and decide the case as a matter of law. For example, suppose that the parties can agree that they entered into a life insurance contract but dispute whether the policy applies when there is a suicide. The facts are not in dispute. The law on payment of insurance procedures in the event of a suicide is the issue. Such a case is one that is appropriate for summary judgment. Designation of expert witnesses. In some cases, such as involving product safety, the parties may want to designate an expert witness. An expert witness is a witness who has some special expertise, such as an economist who gives expert opinion on the value of the future lost income, or a scientist who testifies about the safety of a prescription drug. There are rules for naming expert witnesses as well as for admitting into evidence any studies or documents of the expert. The purpose of these rules is to avoid the problem of what has been called junk science, or the admission of experts' testimony and research that has not been properly conducted or reviewed by peers. The trial. Selecting a jury. Jurors drawn for service or are questioned by the judge and lawyers to determine whether they are biased or have any informed judgments about the parties in the case. Jury selection is called voir dire examination. For example, in the trial of Martha Stewart, the multimedia home and garden diva, it took a great deal of time for the lawyers to question. The potential jurors about their prior knowledge concerning the case, which had received nationwide attention and much media coverage. Lawyers have the opportunity to remove jurors who know parties in the case or who indicate that have already formed opinions about guilt or innocence. The attorneys questioned the potential jurors to determine if a juror should be challenged for case. Example: when the prospective juror states he is employed by the plaintiff's company. Challenges for cause are unlimited, but each side can also exercise 6 to 8 preemptory challenges. A preemptory challenge is a challenge that is used to remove a juror for any reason except on racial grounds. Opening statements. After the jury is chosen, the attorneys for each of the parties make their opening statements to the jury. An opening statement, as one lawyer has explained, makes a puzzle frame for the case so jurors can follow the witness and place the pieces of the case, the various forms of evidence, within the frame. A presentation of evidence. Following the opening statements, the plaintiff presents his case with witnesses and other evidence. A judge rules on the admissibility of evidence. Evidence can consist of documents, testimony, expert testimony, medical information from exams, and even physical evidence. In the case of testimony, The attorney for the plaintiff conducts direct examination of his witness during his case, and the defense attorney conducts cross-examination of the plaintiff's witness. The plaintiff's attorney can then ask questions again of his witness in what is called redirect examination. Finally, the defense attorney may question the plaintiff's witness again in recross examination. The defendant presents her case after the plaintiff's case concludes. During the defendant's case, the lawyer for the I got some things to skip through. We're on page 24. The lawyer for the defendant conducts direct examination of the defendant's witness, and the plaintiff's lawyer can then cross-examine the defendant's witness. Motion for a directed verdict. A motion for a directed verdict asks the court to grant a verdict because of even if all the evidence that has been presented by each side were true, there is either no basis for recovery or no defense to recovery, or no defense to recovery. For example, suppose that a plaintiff's company presented evidence that an employee who quit working for the company posted on his Facebook page, "I just wasn't happy there." The company might not feel good about the former employee's post, but there is no false statement and no breach of privacy. The evidence is true, but there is no legal right of recovery. The defendant would be entitled to a direct verdict. A directed verdict means that the party has not presented enough evidence to show that there is some right of recovery under the law. Closing arguments or summation. After the witnesses for both parties have been examined and all the evidence has been presented, each attorney makes a closing statement. These statements are also called summations. They summarize the case and urge the jury to reach a particular verdict. Motion for mistrial. During the course of a trial, when necessary to avoid great injustice, the trial court may declare a mistrial. A mistrial requires a do-over, a new jury. A mistrial requires a do-over, a new jury. A mistrial can be declared for page 25. A mistrial may be declared for a jury or attorney misconduct. For example, if a juror were caught fraternizing with one of the lawyers in the case, objectively would be compromised, and the court would most likely declare a mistrial. See also e-commerce and cyber law. Google's impact on trials for more information on juror misconduct and case dismissal. Jury instructions and verdict. After the summation by the attorneys, the court gives the jurors instructions on the appropriate law to apply to the facts presented. The jury then deliberates and renders its verdict. After the jury verdict, the court enters a judgment. If the jury is deadlocked and unable to reach a verdict, known as a hung jury or a mistrial, the case is reset for a new trial at some future date. Motion for new trial. Motion for judgment. NOV. A court may grant a judgment non obstinate verdicto or a judgment NOV, notwithstanding the verdict, if the verdict is clearly wrong as a matter of law. The court can set aside the verdict and enter a judgment in favor of the other party, perhaps one of the most famous judgments, NOV, occurred in Boston in 1997, when a judge reversed the murder conviction of Nanny Louise Woodward, who was charged with the murder of one of her young charges. Post-trial procedures. Recovery of cost/attorney fees. Generally, the prevailing party is awarded cost. Costs include filing fees, services of process fees, witness fees, deposition transcript costs, and jury fees. Page 26. Costs do not include compensation spent by a party for preparing the case or being present at the trial, including the time lost from work because of case and the fee paid to the attorney. Although lost wages from an injury are generally part of damages, attorney fees may be recovered by a party who prevails if a statute permits the recovery of attorney fees, or if the complaint involves a claim for breach of contract and the contract contains a clause providing the recovery of attorney fees. Execution of judgment. After a judgment has been entered or all appeal rights have ended. After a judgment has been entered or all appeals or appeal rights have ended, the losing party must pay that judgment. The winning party can also take steps to execute or carry out the judgment. The execution is accomplished by the seizure and sale of the losing party's assets by the sheriff according to a writ of execution or a writ of possession. Garnishment is a common method of satisfying judgment when the judgment debtor is an employee. The appropriate judicial authority in the state garnishes, by written notice to the employer, a portion of the employee's wages on a regular basis until the judgment is paid. Alternative dispute resolution, ADR. Parties can use means other than litigation to resolve disagreements or disputes. Litigation takes significant time and money, so many businesses use alternative methods for resolving disputes. Those methods include arbitration, mediation, and several other formats. Figure 2.4 provides an overall view of alternate disputes resolution procedures. Arbitration. In arbitration, arbitrators, which is disinterested persons selected by the party to the dispute, hear evidence and determine a resolution. Arbitration enables the parties to present the facts before trained experts familiar with the industry practices that may affect the nature and outcome of dispute. Arbitration first reached extensive use in the field of commercial contracts and was encouraged as a means of avoiding expensive litigation and easing the workload of courts. However, over the past decade, the popularity of arbitration has declined because of increasing procedural burdens and longer and more complex hearings. There have been an increasing number of cases in which arbitration clauses have been set aside as too onerous for consumer or small business party to the agreement. A number of states have adopted the Uniform Arbitration Act. Under this act and similar statutes, the party with a contract may agree in advance that all disputes rising under it will be submitted to arbitration. In some instances, the contract will name the arbitrators for the duration of the contract. The Uniform Act requires a written agreement to arbitrate. The Federal Arbitration Act provides that an arbitration clause in a contract relating to an interstate transaction is valid, irrevocable, and enforceable. In a contract subject to the Federal Arbitration Act provides when a contract subject to the Federal Arbitration Act provides for the arbitration of disputes, the parties are bound to arbitrate in accordance with the federal statute, even if the agreement to arbitrate would not be binding under state law. Mandatory arbitration. In contrast with statutes that merely regulate arbitration when it is selected voluntarily by the parties, Some states require that certain kinds of disputes be submitted to arbitration. In some states, by rule or statute, the arbitration of small claims is required. Finality of arbitration. Most parties provide within the arbitration agreements that the decision of the arbitrator will be final. Such a clause is binding on the parties even when the decision seems to be wrong, and can be set aside only if there is clear proof of fraud, arbitrary conduct, or significant procedural error. Mediation. In mediation, a neutral person acts as a messenger between opposing sides of a dispute, carrying to each side the latest settlement offer made by the other. The mediator has no authority to make a decision, although in some cases the mediator may make suggestions that might ultimately be accepted by the disputing parties. Page 28. The use of mediation has the advantage of keeping decisions going when the disputing parties have developed such fixed attitudes or personal animosity that direct discussion between them has become impossible. Med-Arb. In this new form of alternative dispute resolution, ADR, the arbitrator is also empowered to act as a mediator. Beyond just hearing a case, the arbitrator acts as a messenger for the parties on the unresolved issues. Expert panel, particularly in the construction industry, one of the tools of alternative dispute resolution is the submission of a case, or perhaps a particular issue, to a panel of experts in the industry. This method has gained popularity in the construction industry, where there can be technical questions about breach, including issues related to materials, processes, and delays. These experts can focus on these issues and not be caught in the procedural grind of either litigation or arbitration. Reference to a third person. Many types of transactions provide for the reference to a third person, in which a third person or a committee makes an out-of-court determination of the rights of persons. For example, employees and an employer may have agreed on as a term of the employment contract that claims of employees under retirement plans will be decided by a designated board or a committee. In a sales contract, the seller and buyer can select a third person to determine the price to be paid for goods. Construction contracts often include a provision for disputes to be referred to the architect in charge of the construction with architects. Oh man, that's a tough one. Okay. Construction contracts are often a provision for disputes to be referred to the architect in charge. Oh, God damn it. Excuse me. Construction contracts often include a provision for disputes to be referred to the architect in charge of the construction, with the architect's decision being final. These referrals often eliminate the disputes of pursuit of remedies. For example, fire insurance policies commonly provide that if the parties cannot agree on the amount of the loss, each will appoint an appraiser. The two appraisers will appoint a third appraiser, and the three will determine the amount of the loss the insurer is required to pay. Associate tribunals. Many disputes never reach the courts because both parties to a dispute belong to a group or an association, and the association tribunal created by the group or association disposes of the matter. Trade associations commonly require their members to employ out-of-court methods of dispute settlement. For example, the National Association of Home Builders requires its member builders to use arbitration. The National Automobile Dealers Association provides for panels to determine warranty claims of customers. The decision of such panels is final as to the builder or dealer, but the consumer can still bring a regular lawsuit after losing before the panel. Members of an association must use the association tribunal, which means they cannot bypass the association tribunal, go directly to a law court. Summary jury trial. A summary jury trial is a dry run or mock trial in which the lawyers present their claims before a jury of 6 persons. The object is to get the reaction of a sample jury. No evidence is presented before this jury, and it bases its opinion solely on what the lawyers state. The determinant of the jury has no binding effect, but it has value in that it gives the lawyers some idea of what a jury might think if there were an actual trial. This type of ADR has special value when the heart of a case is whether something is reasonable under all circumstances. This type of ADR has special value when the heart of a case is whether something is reasonable under all circumstances. When the lawyers and their clients see how the sample jury reacts, they may moderate their positions and reach a settlement. Oh, we're on page 29. I'm not sure if I stated that. Rent a judge. Under the rent a judge plan, the parties hire a judge to hear the case. Under the rent a judge plan, the parties hire a judge to hear the case. In many states, the parties voluntarily choose a judge as a referee, and the judge acts under a statute authorizing the appointment of referees. Under such a statute, the referee hears all evidence just as though there were a regular trial, and the rented judge determination is binding on the parties unless reversed on appeal. If such an appeal, like a court trial, is permitted under the parties' agreement. Mini trial. When only part of a case is disputed, the parties may stay within the framework of a lawsuit but agree that only the disputes issued will be taken to trial and submitted to a jury. For example, if there is no real dispute over who is liable but the parties disagree as to the damages, the issue of damages alone may be submitted to the jury. This shortened trial is often called a mini trial. A mini trial may use a retired judge to make a decision on just the disputed issues. The parties may also specify whether the decision will be binding on the parties as a practical matter. Will be binding on the parties. As a practical matter, the evaluation of a case by a neutral person often brings the opposing parties together to reach a settlement. Contract provisions. The parties' contract may pave the way for the settlement of future disputes by including clauses that require parties to use one of the means of ADR. Other provisions in contracts that serve to keep the parties' claim with the hope of resolving. Other parties in contracts that serve to keep the parties calm with the hope of resolving differences without a lawsuit include waiting periods before a suit can be filed and obligations to continue performing even as they try to resolve differences in issues. The summary for Chapter 2, page 29. Courts have been created to hear and resolve legal disputes. A court's specific power is defined by its jurisdiction. Courts of original jurisdiction are trial courts, and courts that review the decisions of trial courts are appellate courts. Trial courts may have general jurisdiction to hear a wide range of civil and criminal matters, or they may be courts of limited jurisdiction, such as probate court or tax court, within the subject matter of their cases restricted to certain areas. I don't know why they do that. The courts in the United States are organized into two different systems, the state and the federal court systems. There are 3 levels of courts, for the most part, in each system, with trial courts, appellate courts, and supreme courts in each. The federal courts are federal district courts, federal courts of appeals, and the U.S. Supreme Court. In the states, there may be specialized courts such as municipal, justice, and small claims courts for trial courts. Within the courts of the original jurisdiction, there are rules for procedures in all matters brought before them. A civil case begins with the filing of a complaint by a plaintiff, which is then answered by a defendant. The parties may be represented by their own attorneys. Discovery is the pre-trial process Discovery is a pre-trial process used by the parties to find out the evidence in the case. The parties can use depositions, interrogatories, and document requests to uncover relevant information. We're on page 30. Continuing on page 30. The case is managed by a judge that may be tried to a jury selected through the process of voir dire, with the parties permitted to challenge jurors on the basis of cause or through the use of their peremptory challenges. The trial begins following discovery and involves opening statements and the presentation of evidence, including the direct access and cross-examination of witnesses. Once a judgment is entered, the party who has won can collect the judgment through garnishment and a writ of execution. Alternatives to litigation for dispute resolutions are available, including arbitration, mediation, medarb, reference to a third party, associate tribunals, summary jury trials, rent-a-judge plans, mini-trials, and expert panels. Court dockets are relieved and case consolidated using judicial triage, a process in which courts hear the cases involved the most serious medical issues and health conditions first. The triage is a blending of judicial and alternative dispute resolution mechanisms. Oh, and then you have the regular end of chapter stuff, key terms, examples, things like that. It ends on page 30. Chapter 2 does. You have questions and case problems on page 31 to go over. Those are the boxes and figures and things like that. More on page 32. It looks like chapter 3 begins on page 33. Chapter 3, page 33. Let's see if we can start that 1 second. Out, go, boom.